All right, good afternoon, everyone. We're here for a special set of criminal motion hearings. We've got two cases on the docket. The first case that we'll take is Alex Garcia, case number 21MM154 with Mr. Gorman. Good afternoon.
Good afternoon, Your Honor. Thank you for accommodating us on such short notice. This is defense's motion, emergency motion to lift the no trespass order of the residence. When he was arrested on the underlying charges on January 3rd, there was no trespass order entered at the first appearance docket. Since that time, our office has received numerous calls from the victim in this matter. We told her we cannot talk to her. She continues to call. She has stopped by, given us documents, Judge, which we have attached to the motion. And what has caused this to be most pressing is that Mr. Garcia recently had appendix surgery, and he's been living in his car. He has no place else to stay, and he is now recovering from appendix surgery in his car. Because of that, Judge, we felt it is imperative to bring on an emergency basis, as well as considering the facts of the affidavits that we have. We are asking that the court allow him back into his home to lift the no trespass order at his residence, which is Judge, I'm sorry, I'll have to look that up, but his home, wherever it is on the first appearance docket, Judge. And if you look at the affidavits, it appears that Ms. Crystal Rodriguez has indicated under oath that she does not reside at Mr. Garcia's address, and she also makes some other statements regarding the underlying facts. But at a minimum, Judge, for today's hearing, due to the fact she doesn't reside there, we are asking that the no trespass order be lifted so he can go back to his house.
All right, thank you, Mr. Gorman. State, any response?
Yes, Your Honor. I was able to make contact with the victim yesterday. She did attest to the facts that Mr. Gorman stated, including that she does not want a trespass order at that address. She does not live at the address and a trespass order was for. And she also stated she does not want a no trespass order at any other address that she's currently at. She also stated to the additional facts that Mr. Gorman stated. The state will not stipulate the motion, but will be given the court's discretion based on that application.
All right. In that case, the defendant's motion to lift the no trespass order at 14875 Mystic Lake Circle, apartment 6104, Naples, Florida, is granted. All other pretrial release conditions shall remain in effect, which would include the no contact order at this time, Mr. Gorman.
Yes, Judge. I'm just going to add that to order. Approach, Your Honor.
Yes. All right, thank you, Mr. Gorman.
Thank you, Judge. Thank you for accommodating us.
All right,
Have a good day.
you too. All right, the next case we have on today's docket is Jarrett Berg Smith, case number 20CT777 with Ms. Woodley and Ms. Armbruster. Good afternoon. All right, we have several pretrial motions that were filed. The first one I would like to address is the one titled Motion to Compel. Ms. Armpriester or Ms. Woodley?
Judge, if I could withdraw the motion to compel at this time, the state yesterday afternoon did provide a copy of the CPSO video that we were seeking to obtain.
All right, so you would be in agreement that a Richardson hearing should not be held at this time?
As it relates to that particular video being given to us.
Okay. All right, motion to compel is withdrawn. Next, we'll go to state's motion in limine.
Your Honor, the state filed a motion in limine as relates to the admissibility of the 911 call. The state does plan to introduce a 911 call through the 911 caller. The state will note that the motion was originally prepared and we thought that there may be a witness availability issue. So the state recognizes that the confrontation clause issue in paragraph 5 is no longer relevant. But the state believes that the motion speaks for itself as it relates to the statements and the 911 call being an excited utterance and also being a spontaneous statement since it was made within, according to our witness, will testify to within 15 to 30 minute period of the initial incident occurring.
What's the objective of playing the 911 call if the witness is going to be here to testify?
Your Honor, Your Honor, asking a question as it relates to cumulative evidence.
I'm just asking the question.
Your Honor, if there is any doubt as to the credibility of our witness, these statements again were made at the time of the incident. They are excited utterances, fall under the hearsay exception, as well as the spontaneous statement or the present sense impression exception as well. And again, we do believe that in its totality, the jury, this will not confuse the jury in any manner. It will be to understand what the witness testifies to.
All right, do you have any evidence you'd like to submit?
Your Honor, I do have the 911 call here on it. This looks to you. If I can approach, if you'd like to listen to it now,
Well, I think it would be appropriate to listen to it now.
Yes, Your Honor, I will warn the court there is language on here that can be offensive. And we are on public record history.
It is what it is.
Yes, Your Honor. Would you like me to play it on the computer or?
Yes, that'll be fine. Just make sure you've got the microphone close enough to it so that I'll be able to hear it.
Yes, Your Honor. May I see it?
You may. Any objection to the introduction of the 911 call for this proceeding?
The only objection I have is we were walked with online for this purpose. We don't know if it's going to be introduced or not.
Well, if we weren't in a pandemic, the public would be able to be in here, so denied. Is this from the beginning?
It is, Your Honor.
Can you replay it, please?
Absolutely, Your Honor. And just as background, my understanding is that based on my understanding from speaking with law enforcement officers is that based on the location of where the call came in, it was routed through various, I guess, operation centers. And that's why the call picks up as they're connecting to another operation.
All right. And do you have your volume turned all the way up?
I do, Your Honor.
All right, thank you.
I don't want to go back. No, he's not go back. He's behind you, though. Sir? Yeah. Caller, dispatcher, he's on the line. He said, ma'am, I cannot hear you. Hi, this is Collier County. I've got a driver, truck driver, having a contact with the driver that's supposed to be drunk on the mile 17 bound. You know, like, going north on I-35. And he said he had to, I don't know who he's on the phone with, but he said that he had to block or something like that. And so he go out and shoot. Okay, what does he look like? He's white, black, or he's Hispanic? He's white. He has a red and black pants, a black shirt. What color is his car? Gray, like a silver color, gray. Okay, a gray Hyundai. Okay, so we have a gray Hyundai, and the gentleman is wearing. Yes, ma'am. And the trailer that hit him. Because I can't see. Okay, are you pulled off on the side of the road, sir? Yes, I'm on the shoulder. I can't see anything, really, ma'am. I can't see anything. And the truck that I have is a bigger truck. But my truck is not damaged. Because like I said, I saw him. And when he saw me, because what I did, I saw him. And I swerved over to the grass. And as he saw me swerve, he put his car in reverse. And he was on the phone telling them that he was trying to make a U-turn. How are you making a U-turn in the middle of the interstate? How do you do that? And my name is spelled Nithos. Last name is Lode. My birthday is 3/29/80. What is your phone number?
And I can 813-892. You get the 892?
Yes, I have 813-892.
Okay. Okay, 7503.
Okay,
I
no longer have you own that vehicle, correct?
No, ma'am. No, ma'am. I'm not going to change you.
No, it's not.
No, ma'am.
No, you don't have to. You're going to put yourself in harm's way or yourself already.
Yeah, and he said something about what? Because I don't know who he was on the phone with. That's the thing. And I didn't see any damage on my trailer. I don't even know if I hit him or not.
Sir, what mile marker are you pulled over at?
69. Between 69 and 70.
That's on the line. You're calling your office? Yes, okay.
I can't see. Okay, I got my flashlight. Okay, here we go. I got my phone light. There's no damage to my trailer. I don't even know if I hit him or not. That's the thing.
Okay.
Oh, okay, here we go. All right, so basically, when I swerved around him, he backed up into my trailer, and my tire, my tandem hit his car. That's the only damage I see. Unless it's just rocks. I don't know. I'm confused right now because I don't really see anything. I don't see anything. I really don't. I don't see any scratches. There's no damage to my trailer. There's no. I had to have hit him because I saw him before and there was no thing. So that's what I'm saying. I had to have hit him. Or you know what I'm talking about. Like I said, he was, no. Alright. Sorry about the rain. I got to come back to the truck. Alright. So, as I'm coming down. Okay. Do you need me to tell you what, or do I have to talk to him? Yes, I'll take that. Because I got the camera and the phone and whatever they like, or his license off of my phone. Yes, ma'am.
Do you want everything on the line until sheriff or deputy gets to you, or do you want to disconnect and give us a call back or wait for him to get there?
I don't know the procedure. I've never been through this before. Never happened. So I don't know. I mean, if you're just the option, I don't want to hold you. You might have another emergency.
Right, and no, I understand, and I'm not generalizing you. I want you to one day generalize until when a deputy or you bring it to you.
No, he's gone. Like I guess he figured out that whatever he pulled off, he couldn't stick to it because it doesn't make sense.
Okay, you said you have to.
I got you. Now I don't have video footage of him
is KXJT7.
That I'm going to see the alphanumeric.
No. It's KX, K as in Kentucky, X as in Xavier, J as in Jason, T as in Texas, number 2, and 7. And then Nissan, like a silver or gray Nissan. I don't think, it has a really big dent in the back. Like it's totally smashed. And he was drunk. When I swerved into the, like I said, I was in the right lane. And he came from behind me to the left side and swerved in front of me. He tried to put me on my left side, but I saw him coming and I slowed down. And he made me slow down to like 55 miles per hour. And then when I saw him, he just tried to hover around in front of me. So I let him go. I backed off and he sped up. He's gone. Didn't see lights or anything. He was gone. Next thing I know, I got back up to speed, 70 miles per hour. And then all of a sudden, I see this figure in the middle, in between the lanes, right? And he goes backwards. Like I saw him backing up, and then I swerved, and then he backed into he's trying to counteract me as I swerved into the left. I swerved over to the left shoulder, or thank the shoulder, to grass at this point. And I went into the grass, and I thought I missed him, but apparently I didn't. Because I think my trailer hit him. I know my trailer hit him. Because he was backing into me.
Is the subject vehicle still heading north-south, do you know?
He has to. There's not an exit that I see at this point. And he sped off pretty quick. He's gone. So he had like a beard, I went to like a lumberjack. His beard is like goatee, or it's connected from his sideburn around his chin. And then he had like a mustache, whatever it connects to that. And then he has like a weird off haircut that's growing back. I'm actually taller than him. I'm actually 6 foot even. And he's a little shorter, so I say he's about like 5'10", maybe 5'9". I didn't see his eye covered. I'm sorry? No. Okay, so this is what happened, right? So as I'm thinking I missed him, right? So he pulls in front of me as I'm in the grass. I'm all the way in the grass at this point. He pulls in front of me, still in the road, gets out his car and says, his next word is like, you hit me, nigga, you hit me. And I'm like, I feel so I jumped out the truck. I said, you stop in the middle of the fucking road. And then you back up into me. And I got to beat your ass right now for doing that. I got to kill you like that. And then you said you hit me, nigga, you should watch how you drive. I said, you in the middle of the road reversing. You in reverse. Why would you do that? And then, so as I'm standing right next to him at this point. I'm like breath to breath right at this point because I'm pissed because he did that. They said he was drunk until he staggered back to his car. Right? And I'm like, oh, he's drunk. Because he's walking he's walking at an angle. And he's with his arms up hey, you hit me later. And I'm like, okay. So he jumps back in his car. So he goes back to his car, opens the door, and he stands there. And he grabs his phone. And then so I stopped my truck, I threw off to chill. And with my flash on. So he's trying to run and take a picture of my trailer license plate. Okay? And then conversation he had on the phone, he said, the nigger hit my car, he just hit me in the middle road as I'm trying to do a U-turn. And then he said, should I pull my, he said, that word, should I pull my block out and shoot him? Should I shoot him? Like that. And I was like, oh, so I'm like, all right, he's talking about shoot me. So I just stand there and take a picture. I took a picture of like the plate, and I was like, all right, so I get my truck. And then, so he stands back out, and he's still talking or whatever. So then he was asking, I would have to make sure it was a Hyundai or, to see what I actually saw, because I didn't see it clearly. So I jumped back out, and I looked in front, so he gets back out of the car, staggering at this point. He's like literally reaching against the car as he's trying to keep going. And then he steps out, and then he tried to post me. But what I did, I looked at the front of his symbol, and it was like, oh, it's a Nissan. And at that point, I was like, I don't know, Altima or Maxima. So I go back into my truck. And at that point, I'm sitting here, and he jumped back in his car and blew us off, and he's gone.
Okay, so you no longer have a visual that shows one of the vehicles no longer in sight.
No, he's no longer in front of me. Like I said, I don't see any really damage to my trailer. The only indication is the tire, my handle, right handle. And I think that's what happened when he was back in his car, and I swerved around him. Because like I said, he's already backing up as I approached him. He had lights turned off and everything. I don't know if he was trying to do an insurance fraud or what. But yeah, he had his lights turned, he had his car, like all the lights turned off. And then the only time I saw him was when he started to reverse, and his reverse light came on. That's the only time I saw anything. Because like I said, it's pretty dark, and he was way ahead of me. And then he was in the middle of his car was parked in the middle of the lane, because it's only 2 lanes. And as I'm coming up, I got my check back up to the speed limit. I already see him as far as my lights are shining. And then I saw him, his brake with his front light kick on. So I'm like, what is this dude doing? So I'm braking. And then I'm like, wait, where's he going? And I see his car started to run towards the right. So I swerved to the left. And then he counter steered back to the left, where he steered into my truck. I guess he's trying to do a head-on collision to my truck, but I already had swerved around ahead of time, and he hit my trailer.
They are always the area for the artist
There's somebody behind me, but I don't know if it's you or not. I think it's one of those bad options or something.
careful, you're making artist practice.
No, I'm not gonna get out until the officer comes and asks me to get out. I'll talk to him right now. I'm still got a drilling going right now, and I don't need to be yelling and raising my voice, but I'm nervous. I got a drilling going to me right now because like I said, he started when I saw him, he was burning. And I almost did like a head over. Like I said, I already saw him ahead of time when he was first like kicked on. I reacted immediately and I swerved to the left. I don't know if he got it. I don't know who this is. He's way like towards the back. He got some type of like
Pull over at the 69. 69.5 close to 70. Means that if there's a vehicle on my end, I think it's a no.
Yeah, I'm not getting out. Sorry, my chest is pounding right now. Still got a nervous going.
Totally understandable.
Maybe I should have, handled that better. I should have walked out when he came up on my truck. After he pulled out in front, I should have thought of my safety. But I was pretty pissed off at that point because I don't know what would he think he's trying to. He's literally on the phone saying he's trying to make a turn. How do you do a U-turn on I-75 on a two-lane traffic going one direction? How?
This message is on the line. Yes, ma'am. Okay, and it's none of your units that are behind the semi. What else? Like the speaker? Okay, this is not the road rangers, and it's not our unit. If it is our deputy, we walk out to him. Okay.
Yeah, there was no point in trying to. Yeah, there's nobody I don't want to say like 100, maybe 100 yards behind me. I don't know if he's like doing a safety type of thing. Like I see lights flashing behind him, they're like amber. Like now, like well,
They're not ready.
no, ma'am.
Probably not.
Yeah. I'm gonna say like 100, maybe 100, maybe 200 feet. Same thing if I would put my triangle down. Yeah, ever, approach the vehicle or anything.
Sure. And just to verify
Yeah.
that you're on Market 59 on Alligator Alley.
So,
Yes. Yes.
yes, ma'am. Yeah, because I had moved up when the guy said the mission he had blocked. I mean, I didn't really get him, but, you know, you never know these days, you know, so I moved up from him. Right, yeah, so I moved up away from him. Okay. Pull it up. I don't know. Yeah, correct behind. Got the frame on. Hi, are you talking to me or?
Yeah, I think he's still there too.
Yes, this is behind.
Okay, because the rangers are there, I'm gonna go ahead and connect them, okay?
Yes, I appreciate it. Thank you.
All right. I'm gonna go ahead and connect as well. If you feel, you know, that we'll have some feedback, all that.
Okay, well, that's Law Rangers. No. I mean, like I said, I'm good now. The guy's gone, and I'm just waiting on him to leave. Like I said, I've never been through this before. I don't know the procedure. She said it's okay to disconnect, and I think, you know, I know you.
What happened and if you contact that people that we can report it and report to your company. You are ready.
Yes, ma'am. Yes, ma'am.
Okay, well, already, there's that, you know, it's self-hard,
Yes. It's our 60. Okay, thank you. Okay, I appreciate it. Thank you very much. All right.
All right, any additional argument, Mr. Rab?
Yes, Your Honor, as the 911 caller stated in the video there, or in the audio recording, there was clearly an incident that caused him excitement. He mentioned in the call that his heart was still pounding well into the call this entire time. He's clearly within a 30-minute window, which Florida appellate courts have held previously is sufficient for spontaneous statement as well. The state believes that this falls again under the excited utterance exception to the hearsay rule as well as spontaneous statement.
All right, thank you. Response?
Thank you, Your Honor. First of all, if Mr. Love Lunford is going to be here, I'm not sure point of having cumulative evidence of testimony and then the 911 call if he's going to be testifying to the same thing. But if this does come in, I would be asking for some redactions for the following. Now, if the video is to be played, he cannot testify to anything that is qualified as an expert, such as drunk. I believe he said to dispatcher, he's staggering because he's drunk. I'd be asking for that to be redacted. He cannot, and as an expert, and certainly cannot testify to that, and that would be very highly prejudicial. And again, he's not an expert and can't testify to that. Another thing I'd ask for a redaction is calling it insurance fraud. That's pure speculation. There's nothing to state that there's evidence to show that, and that's just speculation. So I'd ask that to be redacted.
Right, Ms. Woodley, let me stop you. Let's speed this up a little bit. Let's not talk about redactions. Let's just talk about the admissibility of the 911 call at this time.
I'm fine if the video is admitted if we redact a lot of it.
You mean the 911 call?
Or, I'm sorry, 911 call. If that's redacted, a big chunk of it's out, and racial slurs, these experts as calling them drunk, if all that's redacted and taken out, I'm fine with being introduced, but we do a lot of redactions.
Well, I thought you just argued that it was cumulative in nature.
Depending on his testimony, I would actually like to use it for myself in case I need to impeach him or not. Testify.
Well, that's not why we're here. We're not here regarding impeachment evidence. We're here for the admissibility of the state's in chief evidence.
Yeah. And
If a motion in limine is granted, it doesn't mean it can't be used for impeachment.
certainly, and if the state's position is they have one for blood coming in, it seems cumulative to me to have both the 911 call introduced and have them testify. So,
Any last argument, Mr. Rabb?
Yes, Your Honor, if I may respond. I wasn't necessarily prepared to argue cumulative evidence today. However, simply because evidence is cumulative does not mean it per se prejudices the defendant. Everything that Mr. Rumford has been testified to is, from our understanding, going to be what's in the 911 call, and there's nothing in the 911 call that's going to confuse the jury in any way as it relates to their ability to understand and sit as a prior fact for this case. I will point the court to case law, Your Honor. Apologies, it's been a while since I've argued cumulative, but Peterson v. State, 154 Southern 3rd, 275, from the Florida Supreme Court. I'll also point the court to, sorry, Your Honor. And I would butcher the name, so I'm just going to spell the last name for Your Honor. It's S as in Sam, A-M-I-I-A-N. Citation is 302 Southern 3rd, 966. That's other person today. And as well as Victorino v. State, citation 127 Southern 3rd, Supreme Court. And again, Your Honor, the state's argument would be simply because evidence is cumulative, it does not per se prejudice the defendant under 403. There is nothing in that call, and together with the testimony from the witness, that in any way is going to prejudice the defendant or confuse the jury.
So you don't think there's anything in that phone call that's prejudicial, that outweighs the probative value?
Your Honor, you're referring to something in specific that is still on the docket for a motion hearing. I'll just going to make that argument at the proper time. But outside of that, Your Honor, as it relates to 403, the cumulative issue, I do not.
All right. State's motion to admit the 911 call is denied. All right. We'll go next to defendant's second motion, titled Second Motion in Limine.
Your Honor, based on your ruling of denying the state being able to bring in the 911 call, I would withdraw my second motion in limine as it relates to that.
All right, state defendant's motion titled second motion in limine is withdrawn. That brings us to the defendant's motion titled motion in limine objection to state's video redactions.
Yeah. If we could go back, Your Honor, to the second one for a moment.
The one that you just withdrew?
Yes. I will draw that.
Okay. Nothing. It's already been withdrawn.
All right, the state did yesterday afternoon give me the redactions, and I have a lot of concerns starting with the first. I'll just go down the list. I've got some minute times here. The first 3 minutes of the video is not relevant. My client is seen talking on his cell phone to his girlfriend, but there's nothing to go to charges that was, or the elements of the charge that he's impaired or driving, so I don't see the purpose of having the first 3 minutes.
All right, response.
Yes, Your Honor. In that phone call, the defendant states that his girlfriend should go to the gas station off I-75 in Weston because that's where he believes he was. He was in fact at mile marker 89, well within Collier County, about 10 miles east of our Bluth and Golden Gate. I think this goes to his state of mind and perception, as well as his normal faculties. That's certainly an element of crime that's being charged with the felony.
All right. Anything else, Ms. Woodley?
No, I'm just, again, don't see how talking on the cell phone to your girlfriends at all.
All right. Defense motion in limine as it relates to the first 3 minutes is denied.
Next would be at minute 12 minutes 41 seconds, when he is put in handcuffs.
Is this in the motion?
It should be.
I actually never received it, but
It did say to me I got the CD at 1 o'clock, by the time I went through it, it might not have got filed until after hours.
See what the notice of hearing is on.
The motion in limine that's in the court file has exclude the following portions of the state's redactions, and it lists A and B, the first 3 minutes, and then exclude 15 minutes until the end of the video.
Yes, at 15 minutes, and really that will, if I can add an additional.
Let's go over the one that's in the written motion.
Okay. From 15 minutes to the end, he is in the back of the patrol car, and there is nothing relevant to go towards showing the elements of the charge. He is having one panic attack, he's crying, he's making what I believe the jury will see is confusing to them because he's cursing, and really, it's, even if it was relevant, it's so prejudicial that the jury is just going to be confused by foul language and cursing, that there's nothing to show impairment. It's my guy crying, my client's crying on set, and there's nothing more than that.
Mr. Rep,
And oh, I'm sorry, I did forget something else that I can add.
regarding that
Yes.
ground, yes.
He also discusses while he was crying, he's scared to go into the jail because of the pandemic.
yes, Your Honor. Contrary to prior arguments, you do not need to be an expert to make observations of impairment. I don't think that the observations that are observed in the back of a patrol car, potential mood swings, the defendant's ability to make judgment decisions while he's in the back of a patrol car, including a half-hour tirade cursing out a law enforcement officer, is by any way confusing to a jury. they are the trier of fact. They are able, as lay people, to make those same observations as you and I would, as it relates to potential signs of impairment. And the state certainly believes that the statements made in the back of the patrol car, along with the actual physical actions of what is appeared to be in the back of the patrol car of the defendant, are all relevant and certainly go to the normal faculties again of the defendant.
And I would respond.
Don't I need to see this video in order to make a proper ruling?
Yes, I do have the video. And if you'd rather, you can plug it into your computer. I do have a portable drive.
Well, it sounds like it's mostly audio, so if you want to play it from there.
It is in the car, Your Honor.
I'm sorry.
It is in the car in the backseat.
It's mostly, most of the video
Right,
is just in the car.
Is the purpose of this segment of the video for audio purposes mainly?
It would be both, Your Honor. I think that the jury can make a determination based on his potential facial expressions, based on how he's moving in the backseat, and based on statements.
And further my argument, I can just add something, but most of the video it's 15 minutes of field sobriety exercises and at least 30 minutes of my client cursing and crying, which doesn't go to the elements of the DUI.
Let me state this. How does the probative value of this segment of the video outweigh the prejudicial effects, considering at this point he's already under arrest for DUI, correct?
He is, Your Honor. However, just because he was placed under arrest does not mean that there are not signs of impairment subsequent to that arrest that the jury can use to determine whether or not his normal faculties are impaired. Again, particularly judgment in this case. And based on that, Your Honor, I do believe that the probative value of that video outweighs any prejudicial effect. It goes straight to the elements of the crime that he's being charged with.
And that element would be impairment.
Yes, Your Honor.
All right, let's see it.
And would you like me to put it on my computer?
Yes, please.
Would you like to start first, Your Honor?
I'll be able to see it from there. If you could just make sure it's close enough to the microphone and that their volume is turned up, Ms. Woodley.
I will. I'm good. Can I start it at the 15-minute mark where you put in the visual part?
That's what your motion says. Do you want to turn your computer screen around so I can see it?
Oh, so.
I can see it.
Yo, this is fucked up, bro. Yo, this is messed up. I got hit by a car and now they're arresting me. Are you serious? Are you serious?
guys seriously arresting me after I just got hit? You're really gonna arrest me after I just got hit? Can you please tell somebody that I just, like, got arrested? Hey, bro, please don't let me, man. Hey, what did I fail on? Just the overall exercise, man. You guys messed up, dude. I just got hit by a fucking salon. Or somebody hit me, supposedly. And you're gonna fucking protest me because of fucking you smell alcohol on my breath. Absolutely, you're right. I mean, bro, I got hit. I didn't hit nobody. That's seriously what you guys are gonna do? That's messed up, bro. On my birthday? That's messed up, dude. Messed up, bro. Messed up, dude. This is karma. That's gonna haunt you for the rest of your life, bro. I don't know what you believe in, but hey, look. That's messed up, bro. Hey, you know what? I have a job to do. Hey, listen, you have a job to do, and you have to make a quarter. That's cool. Good, bro. You're at the end of the month. You're gonna go to a quarter because you wasted your time. That's fine, dude. You can rock my fucking cups. 6'5", Hey, look, bro. I don't know, dude. You're messed up, dude. You got no fucking family. I got my fucking car totaled, and then you're gonna fucking put me in fucking jail. Dude, you're messed up, bro. Hey, listen, dude. It is what it is. Remember that. You don't have anything to do with it. Don't fucking have today, bro. You're fucking wrong for what you're doing right now. Taking me away from my fucking family, getting me hit, making me not be able to work, and I just all above, bro. I don't know what you believe in, dude, something's watching over you right now, and it's telling you you're fucking wrong. So, you're gonna try and fucking ride out. That's it, bro. Ride out with your pride, you know? You got 1, 2, and 3 dudes there watching you, so you felt under pressure that you need to do what you need to do. That was good. Do your thing, bro. This is bullshit, bro. 6 o'clock in the morning, 7:37, and you're testing me is right. Come on, man. I've been working all day. I got hit by a fucking truck. My car is horrible. I got hit, and you're gonna fucking text me. Yeah, it's all good, bro. Hey, dude, it is what it is. I don't know what you believe in, but it ain't Jesus. I'll take that out. Because you know why? What's around, bro? You just fucking fucked up, man. You just fucking got me in trouble for no reason, bro. You could have just sent my ass home, got me picked up with no fucking car, and fucking let me go my way. With a fucking red car. Now you're gonna make me deal with this shit, get wanted out, and fucking have this on my record. You're gonna ruin my fucking career working. I'm gonna run it. Yeah, you're I'm gonna run it. Yeah. Yeah. You should have thought about it. You're the one that should have thought about it when you did the sobriety test and could have said, hey, he's good. You're gonna go in that Because you're bored. He's good. It's all right, bro. He's good to get picked up and go home. His car is horrible. I'm an asshole, dude. Like, bro. Like, I'm not fucking a mean person, dude. Like your decisions, your decisions are fucked up, dude. Fucked up. I'll say that right now. Your decision, the way you just handled this was under pressure from both dudes looking at you. Hey, guess what? You got your own fucking tag, bro. Remember that. You got your tag, but you got a problem. Friendly or excuse me? I'm a resident. A sample of what? I don't care. Fuck. Like, dude, you just plugging it somewhere and I don't know what the fuck I'm at. You're not the labels. You're plugging the labels to lock me up, bro. And I live in your pockets. You're a fucking grimy ass person, dude. I got a 6-year-old daughter I'm doing, like, oh, I got a car smashed in, leaving somebody's house, and you're gonna blame it on me? Like, I did something. Or whoever hit you, and ran off. You got stuck on the side of the road, and now you got a DUI. That's all I'm hearing. It's fucking bullshit, bro. I'm fucking good. For whatever it is that got to get me to get me out. Or better yet, I'm gonna sit there because it's a DUI. I never had a DUI. It's my first DUI. You see that on the record. It's alright, bro. That's what we do. You did your job, bro. Congratulations. You got a fucking cookie. You're gonna go home, you're gonna tell your wife, have your kids, but I arrested this guy, he got his car bashed in, but you were drunk, so I'm gonna arrest him. Fuck out of here. I'm not even drunk like that. Like, I just got my car smashed in, and you're gonna surprise test me? That's crazy. It's common sense, bro. If you don't have common sense, I don't know what the fuck you do with this fucking this car. Like, I got my car hit. Why don't you test somebody that's been hit? I pulled in front of him, and I just wanted to stop and kill my life. What fuck? No. I'm not suicidal, dude. I live where my kids live for. You hear this shit all day from fucking junkies, crackheads, whatever the fuck you pull over, whatever people you pull over. Hey, no, I'm not that, bro. You put some shit on yourself, dude. So when you go around the corner and something happens, hey, just remember, bro, you fucked up and you fucking did what you did to me, dude. You're fucking wrong for this. Wrong, bro. Wrong. You're wrong. I didn't drive drunk. I left my friend's house. Going home. And the motherfucker hit you. No shit. No shit. Who the fuck else is that? I don't have a Tesla. A Tesla will self-drive. I don't have money. I know what I have. That's a fucking $50,000 car. Sorry, bro. Just go ahead and open your intake and whatever, and I make sure you come to court, and I make sure you fucking, you know, I want you to speak, I want you to talk. Hey, have pride when you do it too, because I got pride when I talk. I'm fucking American, dude. I'm fucking born here and raised here, and I'm fucking born here, dude. You just fucking took me away from that? Alright. Fucking essential. But I would learn to supply the government, and you just fucking broke me up. Fucking, what was your suspicion? What was your suspicion? Oh, you didn't have a DUI? Yeah, so you put on your eye test for me, your tax. Okay, What does that have to do with me being picked up? Bro, what does that have to do with me being picked up? I'm going home. I'm going to work. Bro, it doesn't matter. You're gonna put me in a fucking jail with fucking crackheads. You're fucked up, dude. You're fucked up person. Killing up people with fucking what's going on? Corona? And you're gonna put me in jail? You're a fucking dick, dude. I swear to God, if I get fucking sick, I'll remember you, bro. I don't give a fuck. I don't give a fuck what car you're in, what the fuck you do, what life you live, where you live, any of that shit, dude. If I get fucking sick because of these fucking crackheads that live on the street because of you, hey, what it is, bro. Come to my fucking court date, dude. Come to my fucking court date. I'm not a fucking lawyer because why? You know, I got pulled over after I got fucking hit. I was in need of emergency. I wasn't calling because I was doing something wrong. He stopped me because of an emergency. My car was disabled. It is what it is, bro. You got my she's out there driving around crazy. You got her with my daughter too? I heard that, right? Alright, cool. It's a fucking handless. Just take it out of here. Hey, look, there was no disrespect until you fucking put cuffs on me, bro. I don't give a fuck if you locked in and if you talk to or not. I gotta be comfortable with this, dude. You're taking me somewhere I don't fucking know where I'm at. I don't know where I'm at, dude. Where the fuck am I? You're just taking me somewhere? Like, come on, bro. This is fucked up, dude. Fucked up, bro. You gotta go to the other side of the fucking town and you're gonna lock me up? Because of suspicion? Your suspicion sucks, dude. I followed your fucking light. I did everything you asked. Yeah, I stepped a couple times sideways. Why? I did sandals. Oh, take your sandals off. Dude, I want to be in platform shoes. If I was fucking my steel-toe boots, whatever. I'm standing fucking straight. Steel-toe boots, standing straight. But you know that though. Maybe you're taking advantage of that. You're gonna look cool in front of your peoples. So you're thinking, bro. I hope you fucking look cool, bro. You're so fucking cool, dude. So fucking cool. Ruining Swiss fucking family, bro. Over nobody. I'm fucking crashing with nobody and murder anybody. I didn't hurt nobody, bro. I didn't hurt nobody. Somebody fucking hit me. And that's what you do? Hey, again, karma is a motherfucker, and that's what it's gonna be, bro. So, do what you gotta do, maybe a little intake, whatever. I gotta fucking see a judge all fucking weekend. Fucking piece of shit, bro. Take your weed away from my fucking daughter, bro. Alright. It's a fucking faggot for the internet, dog. Oh, I have to make a fucking call. Oh, I have to look good. Oh, I pulled this guy over. He pulled shit over. Remember that. You fucking cut me out. That's what you were doing. And you turned it into this. You were cutting me out. And you turned this into this. Okay. Fuck up. There's so many people out here fucking raping kids. Fucking doing drugs, selling drugs. And fucking my people. That's it. Oh, I can't walk my sandals after I got hit by a fucking semi. Fuck out of here, dude. Piece of shit. Piece of fucking shit, bro. You hear this shit all day, I bet. But guess what? Guess what? It's gonna mean something to you. You're gonna remember this shit. You're gonna remember being a fucking asshole. Locking somebody up on their fucking birthday when they got hit. I don't even fucking talk like this. Don't get on your handles. So fucking far away from where the fuck I am. I don't know where the fuck I'm at. You got me somewhere I don't know, dude. Fucking asshole, dude. Asshole. You're bringing around these sick ass fucking people, bro. You know, I swear to God, I'm gonna fucking sit in here. I'm gonna fucking call on you, bro. Trust me, dude. Oh, man. Yeah, 1 mil. 1 mil. Fucking go what? You got it. Fucking asshole, bro. Asshole, dude. Straight asshole. You ain't no pussy. You ain't no shit. I don't know what the fuck's going on, bro. But it ain't my problem, dude. You can disrespect me like this. You're fucking disrespectful, bro. Fucking disrespectful, bro. No problem, sir. You come in the bar. I put my own fucking seatbelt on. For my safety. If you guys ever fucking record fucking.
It's 8 more minutes, but it's just it's pretty much the same.
They're observation.
It's relevant, Your Honor.
We'll continue watching.
You're a fucking asshole. It's not your job, bro. To be an asshole. It's your job to protect and serve. That's all everything to. Try to fucking. I can't be going here like this. I need a lot of fucking anxiety, dude. I have a fucking anxiety, bro. I have anxiety bad. Real bad. Holy shit, why the fuck am I inside here right now, bro? After I just got hit. I should just call the ambulance and fucking got picked up. I should have got picked up, bro. I should have got picked up. I fucking should have got picked up, dude. Fuck. Why the fuck am I in fucking handcuffs? Yo, dude, you're asking for stuff that's not, it's not in my interest right now. If you're asking me how to get home, I'll tell you how to get home. 800 Southwest 131st Avenue, bro. Like, bro, I feel like I'm about to throw up. Like, I'm literally about to throw up. I don't feel good, dude. I do not feel good, bro. You're making me nauseous. No, bro, you fucking are you serious with this sick ass fucking crackhead? You want to go off the street? Yo, you're fucked up, bro. You're fucked up, dude. You got some shit coming out of you, dog. I don't give a fuck what it is. It's not me, bro. It's not me, dude. You fucking fucked up, bro. You fucking just a fucking, yo, you just did some shit that's like fucking unbelievable, bro. Fucking unbelievable. I fucking worked harder than you, bro. You fucking sit in the car all day and fucking pulled me over. I was my ass. I was learning plays right before I learned, like, yo, I'm certified for all this shit, and you just fucking pulled me. And then I hit, and you, oh, it's you, I don't know, it's like, I'm fucking keep going here. Everybody's watching me. Fuck that shit. You should have fucking taken a sobriety test right then and there, bro. You waited too long. Waited too long, bro. Waited too long, dude. You make me nervous right being around all those people, bro. So I'm about to throw up. I'm about to throw up. I don't want to throw up in your car, bro, but I'm about to throw up, dude. I'm going to throw up.
Right. Mr. Reb, tell me again how the probative value of the video in which that section of the video that we watched is not substantially outweighed by the danger of unfair prejudice.
Yes, Your Honor. A claim or a statement of claim 525 2nd. I apologize for not. As well as Hoffman states in 43 2nd, 130. Both of those cases state that everything established describing a person's demeanor or conduct. That is very difficult to do, showing jury simply through testimony alone. That video, the state believes, shows impairment to the normal faculties of the defendant as it relates to violent use and his temperament, as it relates to his unawareness of where he is still 3 hours after being encountered by law enforcement at mile marker 89 on I-75, that he still thinks he's in Broward County somehow. All of that is relevant to the elements of the crime. It's a criminal case, Your Honor. Obviously, ultimately, evidence is going to be prejudicial to some sense to the defendant. But as it relates to establishing those facts to a jury, the state believes that it would be more confusing to a jury to not show that video and to simply try to explain that through testimony alone rather than to show them exactly where it fell.
Why couldn't Officer Hernandez just testify as to his conduct en route to the jail?
He's certainly could, Your Honor. Again, the state's position is simply that testimony alone is very difficult to describe what is seen in that video. That video is the best evidence for the jury to determine whether or not those are scientifically permanent for the defendant.
And so if somebody gets arrested for the first time and gets upset about it, that's a sign of impairment.
Your Honor, I believe he stated that he did not have a prior why he said that it was his first class.
I don't know if it was or not.
Your Honor, again, it may be, but I think that's a really hard fact.
Right. Ms. Woodley?
Here's one.
Go ahead.
So this video is 42 minutes, and 30 minutes of it spent what we just listened to. 32 minutes of it are in part crying, in fear of corona, afraid of losing his job, being away from his family, afraid of, again, going to the jail, upset about a car accident. He doesn't know what's going to happen with his car, or I should say, his fiance's car that's alongside 75. All of these things have nothing to do with whether he's impaired. And if this goes in front of a jury, a panel of people are not going to be able to focus on impairment. They're going to get confused, and they're not going to be able to focus on different elements. And it's cumulative evidence. The Officer Hernandez, is going to be able to testify. We'll have Mr. Lunsford here to testify. As far as his conduct in the patrol car, Officer Hernandez can certainly testify to that. And anything, the 30 minutes that we just listened to, there's nothing that can come in that's going to go towards impairment. It's only going to be outweighed by prejudice when it comes to the jury. So I'm asking it to be excluded. Number one, because it's cumulative, and two, because it does not go with impairment. It might show my client is difficult, might show he might have a anxiety disorder, or it might just show he's got really upset because he's never been in the patrol car, or he's never been and without his looking at his prior in front of me, I'm not seeing it. I actually don't have his prior in front. But he was upset. This is little impairment. So I'm asking it to be excluded because it has nothing to do with impairment. the only way that we can sit very confused and possibly focus on that. And that's what really happens, focusing on personality in those traits.
Thank you, Ms. Woodley. Mr. Rabb, did you have something else?
Yes, Your Honor, if I may.
Well,
Your Honor, as to the matter of cumulative evidence, this was a battery case. The victim was at bruising, but not the cumulative evidence to show a photo of the bruise, of essentially what was a sign of the crime that was committed. This is very similar to that. I'm not sure how anger cannot be perceived to a trial back as a symptom that someone is under the influence of alcohol. Again, based on layperson opinion, which we are all able to make, as it relates to signs of impairment. Anger is one of those that I think for you people would say is a sign of impairment of consuming alcohol. It could certainly include that. That is an issue for a trial back.
all right, thank you. All right, as it relates to defendant's motion regarding was it the 15-minute mark?
Yes.
The 15-minute mark and beyond, the court finds that the probative value is substantially outweighed by the danger of unfair prejudice and grants the defendant's motion as it relates to that ground. Ms. Woodley, did you say you have an aura tennis motion in
Yes, Your Honor, it's standard draft motion, if I could refer on that. And I do apologize for not being able to.
Yes. What's your ground for relief?
I'm sorry.
What's your ground for relief?
My ground that at 12 minutes, 41 seconds, it was right after she was arrested. There's cursing and again, not relevant. And it wasn't confused the jury.
So 12 minutes and 41 seconds to what?
I'd actually asked, that's the time of the arrest, so if we could have it go from 12 minutes to 15 minutes. Because when he was arrested. Right when he was put in handcuffs, when I asked up, and there's perfect.
All right, I guess we better watch it. Where are we starting at, Ms. Woodley?
12 minutes, 41 seconds.
Can you tilt your screen down just a little? Thank you.
Yes, sir.
And then review it here, 15 minutes.
All right, and what's your argument?
Throughout those 2 minutes is the time of the arrest. You hear him cursing, fuck this, and there's nothing that's going to come from it. Using the jury, even if kind of relevant, is only going to prejudice him, be outweighed by the jury.
All right, Mr. Rab or Ms. Bonilla?
That, at the time in which the defendant was arrested, he did make admission in regards to what he was being charged for. And in relation to that, it also proves on the states we have his inability to make judgments, which is also one of the elements we need to prove in order to move out under impairment. So the fact that we have to cut the rest of the video out is based on the court's ruling. We're not objecting to the rest of the video that we have to move out. However, it does relate to his admission of what had happened up until he was arrested. So Judge, we're asking that you allow the rest of the video to stand as it relates to us proving impairment.
All right, so you're talking about the 12 minutes and 41 seconds to 15 minutes. All right, the court denies the defense request for the redaction of 12 minutes and 41 seconds to 15 minutes. All right. Any other pending motions before the court?
Yes, ma'am. I have moved a motion for exclusion of evidence as it related to the video coming in at trial.
Where was this filed?
Line 114, was filed this morning. I'm not sure if it's not within the right
State.
Even also at 2:12. After the terminal.
What's the title of it?
Smith Richardson. Yes, we did receive that motion on, but it was that was, I withdrew the motion to compel the video.
Sorry.
Not to
State it.
I'm sorry?
The state it.
I don't see that it's been filed.
Judge, I can send you a copy.
I have a copy of it. The title of the motion is Motion for Exclusion of Evidence.
Or Smith Richardson, I'm not sure how it got. Judge, I'm asking that it be filed immediately. I'm not sure where it got lost in the shuffle.
Can you print it here?
I believe I can put those pictures. Where is it?
Want to email it to the clerk?
What's your email address?
Yeah. The bailiff's getting it.
Madam Clerk, you should have
Check that.
No, we haven't yet.
Very much.
Okay. I thought we'd check it afterwards. I have a copy of it. Well, I mean, I have a look on
Oh.
it. No, can you go ahead and file it though?
Okay.
Thank you.
Thank you, Your Honor.
All right, go ahead.
Judge, present for the court, I'm arguing one to good evidence. Your Honor, by way of background, this will be filed under experience on our client's behalf. That was their hand for discovery on 15th. Judge, we stated on January 21st that we were ready for trial. All evidence was within. This was set as your Honor recall for Monday. The state again announced that they were ready for trial. On February 1st, when we were at our calendar call, the state was aware that potential video from the trooper from the law enforcement officer in Collier County Sheriff's Office had potential dash cam video. They just were not aware if they were going to use it. Judge, at that court date, they did not inform themselves nor the court that this evidence existed. Judge, yesterday afternoon, the defense was made aware of and given a copy of this dash camera footage from officer with Collier County Sheriff's Office. Judge, we've been set for trial since February 1st. Date started from February 4th, but since January 21st, we've been filed positive, depending on the numbers. Your Honor, in the event of a discovery violation such as what's taking place here today, we're asking that the court will conduct a urgency hearing to determine first whether this discovery violation was willful or inadvertent. We're suggesting that it was willful as the state didn't know about it existing. It wasn't technically in their possession at our 21 court date. Second, whether it was trivial or substantial. Judge will argue it was substantial. And third, whether it has a prejudicial effect on the opposing party trial preparation. Around the video evidence of our clients, the first responding deputy, and what turned out to be a DUI investigation after the terrible car accident absolutely changed how we would prep the trial. Your Honor, I have placed other research in the motion. Mainly, I would like to point Your Honor to paragraph 11 and cite to recent date, 694 Southern 2nd, 1987 case, and Judge, you read that law here, our client, Mr. Smith, is prejudiced by the state's actions, as there is a reasonable possibility, that our trial preparation and strategy would be materially different had this violation not occurred. And Your Honor, based on all of that, based on rule of criminal procedure 3.220 subsection N, that we're asking for sanctions in this matter, that the court would deem appropriate up to an immediate dismissal of the charges against us.
Let me get some clarification from Ms. Armpriester. You received a dash cam video yesterday,
Yes,
and it had not. Who was the dash cam video from?
Officer Munoz of CSO from the state attorney's office.
Is that correct, Mr. Rabb?
Yes, Your Honor.
I might. Let me look at. So in the notice of discovery filed by the state on July 22nd, it lists video dash cam FHP 1 through 7. What does that mean?
That is of Trooper Hernandez. And the FHP sergeant who is with him, nothing from Collier County Sheriff's Office.
All right, and then I see a notice of discovery was filed yesterday, and it is disclosing video in car. Mr. Rabb, that's the CCSO officer's dash cam video.
Yes, Your Honor.
All right, Mr. Rabb, do you believe there was a violation of the
Your
discovery rules in this case?
Your Honor, the sequence of the video was not originally sent to the public defender's office. It was an email thread in our office, and CCSO working is on. And just as background, the arresting agency in this case was Florida Highway Patrol. Our initial request for discovery went to Florida Highway Patrol. That request did not include CCSO dash cam video of Sergeant Nunez, who was the first deputy on scene in contact with the defendant as he was on the side of the road. The email chain suggests, as of yesterday at 10:11 a.m., court liaison stated, yes, I called evidence. He only has 2 videos from 226, 35, 35, 314. None of those videos were videos that were disclosed. CCSO evidence was unable to locate it, in large part because of the 2 agencies having different filing numbers and just being in the wrong place. It was certainly not willful. I do have that email thread the court counsel if you'd like to review it.
Okay.
But it was certainly not substantial. I'm happy to continue with the rigorous what's the court.
All right, and why would you suggest that it is trivial or not substantial?
Yes, Your Honor, it's an hour and 15-minute video that will literally take around 1 hour and 15 minutes to review. There are statements that are made in there that the state does believe are, the state would like to use them in court tomorrow. There are statements in there that are also self-serving to the defendant, and state understands that they will be as well. Again, it's an hour and 15 minutes. It's not substantial. I think it's doubt of a posture.
The video, so this is the first officer to arrive prior to FHP?
Yes, Your Honor, I can give a factual basis for the court if you'd like.
Well,
That wasn't completely true. Are you, when we went down
that's
the line?
okay, I'll come back to you.
Maggie?
Yes. And do you intend on playing this entire video?
Your Honor, I think as it relates to the Richards right now, it's instability. I imagine that defense counsel would record actions that they would want to argue. The state is happy to redact part of the video and provide that to the defense counsel. However, prior to doing that, thought it would probably be sufficient to other in person.
All right, Ms. Armpriester, how has the late notice of this video prejudiced your ability to prepare for trial?
Your Honor, to answer your question briefly, my client does not work locally, so given the constraints of the pandemic, to go over video with him is difficult. And in terms of what the video is on, meaning that there is self-serving hearsay, statements against interest, other forms of hearsay that could be protected or not by the active approach privilege. While I understand opposing counsel's argument to diminish a 1 hour and 50-minute video to having no bearing on my trial prep or what that does in terms of how I represent the client is a misrepresentation. Watching the video itself may only be an hour and 15 minutes, but what's contained on that and the ripple effect it could have on this case is greatly substantial. And on that note, in looking at this email chain.
Could I have a copy of that?
Does the state know about this Friday?
Again, Your Honor, we knew that there would be video and evidence. We're unaware whether or not.
So, Your Honor, the defense's position is that the state knew about this. They didn't even tell us that it was in existence and that they were trying to get it.
The state was unaware as CTSO as it relates.
But to label it as not substantial or willful when for 4 days during trial prep to not let the defense counsel know that this existed is very much substantial.
Well, Ms. Armpriester, wouldn't the more appropriate remedy for this to provide you with a continuance so that you can review that with your client and determine whether or not that would affect your trial strategy?
Your Honor, I need to be statements about that to know at this point in time he wants to go forward with trial. Also signing on, also have to do those findings, the counsel I received with him before court. But no, the defense position is that when we stated ready for trial, we had this evidence to go forward on, that's what we're ready with. And that's what we discussed Monday at last call. And the appropriate remedy is exclusion of this newly discovered and found evidence at trial tomorrow.
Why is that the appropriate remedy? Do you have case law for that?
Your Honor, I would cite to what's cited in my motion, and as to Rule 3.220 and that sanction up to include dismissal and exclusion are appropriate.
Your Honor, if I may respond.
You may.
Your Honor, the state does not deny that the court does have discretion to exclude evidence pursuant to 18 State 760, Southern 2nd 1031. However, citing the State 868, Southern 2nd 650, citing LIABILITY State 725, Southern 2nd 1150. Exclusion is only an extreme option and should be the last resort. The state does agree with the court that the appropriate remedy in this case. I think that is the
All right.
If I can ask a few questions on this matter.
Yeah.
About the video.
Okay.
Does the video have audio? I tried looking.
So the first
Not
30 seconds,
necessarily.
I can try or see. It does have all.
Yes. Well, I do find that there was a discovery violation, that it was inadvertent. I think it has prejudiced the defense in preparing for trial. However, I'm in agreement with the state that it should not be excluded. So, looking at Laidler v. State 10 Southern 3rd 1136, I think it would be error for this court to deny the defense a continuance to adequately prepare, as that could be put at risk, since it sounds like you may have the video, but you may not have the audio file that goes with it. So, with that in mind, defense, do you want to go to a pretrial conference, or do you think between now and 9 a.m. tomorrow is sufficient time to review that and make a determination?
Judge, may we make a decision within the next hour? Maybe we'll move to the jury. If we can go see if the video plays, I can confirm with Mr. Smith. He may still feel as he did at 1 o'clock and want to go forward. But I would like to confirm that our video does have the sound and that that is still his plan.
Would hate to turn down the trial with the jury ready,
Especially if that's what he's gonna want to do in the end.
Well, part of the problem with that is I have to let the jury clerk know by 4.
You have 20 minutes?
And Steve has also made, 20 minutes as it may be, one of the arguments that counsel was making is that the reason for the prejudice, the reason for the, that it was not trivial and that violation was substantial, the client placed in guard, not being questioned, and I don't think very so as well. It is as it relates to any issues after that's what happens.
if I just want to make sure when I open it up, I will record audio and I want to monitor. And I can, if I can do so, and then give you the answer. Soon as the answer will try to get it audio recorded. I'm not sure why our audio did not work yesterday. Or we can, Mr. You can play it now. That would be an option, play it now.
Be a good idea to allow the judge to.
Give me a moment. It's an hour and 15 minutes. Hey, when do we have to know for sure that we need to? Is it 4? Will you call them? Call them right now. Thank you. Checking to see when we have to let the jury clerk know. You may. My concern, well, I have multiple concerns, but chiefly is if the video, how long is the video again? An hour and?
It's an hour and 18.
an hour and 18 minutes. So it's going to take you an hour and 18 minutes to watch it. Presumably that'll be without your client. Then you're going to have to watch it with your client and determine how it affects your case, because you haven't seen it, or you may have seen it, but you haven't heard it. And based on the proffer from the state, it sounds like it could very well affect your trial strategy, or whether or not your client even wants to proceed to a trial. And so if you proceed with trial and he hasn't reviewed it, then we're looking at ineffective assistance of counsel.
The issue that this whole time that we would call them to let him know if he understands that they're going to trial tomorrow. We're not, I don't know if we're going to get there tonight, also we don't have the time family either, so that's why even for those potential claims, we really need to go call Mr. Smith. And I don't mind having if you want to, if the video in the morning, all day or that's really.
That doesn't alleviate the court's concerns.
Has she known about this video since we found out yesterday at 11?
Knowing about the video and what the video contains are two different things.
We planned on using the video a whole hour.
Again, Your Honor, I think the issue at hand is if, just from a timing standpoint at this point, if there are going to be redactions that are requested by the counsel, this is already scheduled to be a 2-day trial. If this matter comes up,
Okay. Thank you. All right. The clerk doesn't have to know until 5 o'clock. So recess and return in $40. They should be. They'll probably have to make additional copies. And the clerk makes a good point. You'll need to provide her with a copy of the 911 call that you played, as well as the video that you played for the motion in limine. You don't have to do that right now because you probably don't have an additional copy, but make sure you get that done.
Thank you.
All right, the court's, what time did I say? All right, court's in recess until 4:40.
getting the videos and stuff, I'm going to mark them as 3 and 4.
Okay, perfect.
Are they both coming from the state? We can,
No,
one for the event, one for the state.
correct.
3 and 1.
All right. All right, we're back on the record for Jarrett Berg Smith, case number 20 CT 777. The attorneys are all present. Where are we with the video that was disclosed yesterday and whether we're continuing this case?
We did watch it. We are ready to move forward with the trial tomorrow. We did not get the redactions. So if the state has proposals for redactions, we potentially hear them now.
Wouldn't you have proposals for redactions?
Yes, I don't believe that any of the video is relevant, so I'd be asking that the entire video be excluded. The officer's going to be here.
So it doesn't sound like we're ready to proceed to trial.
Judge, the defense, if I may, we are ready to proceed. We have watched the video. We renew our objection that we don't find it relevant. We understand that Your Honor has made a ruling that it is relevant and that it is coming in during the time that we were in.
I haven't made a ruling that it's relevant as far as the contents of it.
Understood.
I haven't seen the contents of the video.
I guess it's that, do we have time for Your Honor to watch the video?
No.
Your Honor, the defense is ready to proceed with trial. The state did tell me that they are in agreement with certain redactions. Mr. Rapp wrote down the timestamps. The defense is not in a position to ask for a continuance. We're not going to.
So what is the defense asking? I'm hearing multiple things here.
We're ready to proceed with trial tomorrow.
If the state should provide us with when they provided us with a copy of the video, it should have the redactions that they're agreeing on that we just discussed. Other than that, we'll save our objections for when they try to admit it as evidence.
So the parties have agreed to make redactions to the video?
Certain redactions, Your Honor, as Ms. Armitage stated, there may be additional redactions. I don't know if the court is willing to hear that at trial, or if the court thinks it might be better to simply continue the case at this point and hear a motion.
All pretrial motions will have to be heard before the day of trial. Those were the COVID-19 jury procedures that were sent to all parties. It's now 4:43. I've got to let the jury clerk know whether to bring in a trial tomorrow.
Judge, we got this video 24 hours ago.
Right.
And we set this.
So the appropriate thing then is to continue the trial if both sides are not ready.
Well, it sounds like a state continuance, not defense.
No, that's not what I'm hearing.
Your Honor?
Yes.
Also, I have application understanding that we're on record. Has the determination on the Richardson motion at this point been made, whether you've decided on a continuance or admission? I know you have not decided on exclusion for your ruling. But I think that is also part of the issue we have here. If the court decides based on the Richardson motion, if it's still pending before the court, that a continuance is most appropriate, then my understanding it would be a court continuance at that point.
I don't know that it really matters one way or the other. But from what I'm discerning from what everyone is telling me is that there are, one, the defense for some reason doesn't think the video is relevant and shouldn't be played. Two, that the defense thinks that there are redactions, if it is played, that should be made. But I'm not sure if the state is in agreement with all of the defense's requests for redactions.
That's correct, Your Honor.
Well, Your Honor, there's things on that video such as mention of marijuana, which back in December you ruled would not come in a prior motion and limit. So obviously things like that would have to be redacted.
Just it.
Correct. I did rule that alleged marijuana will not be brought up at trial. And I also ruled I denied the defendant's motion as it relates to fleeing being used as a technical term by the officer used in the report, but granted the defendant's count 2 as to the issue of scientific or expert testimony.
So that's why, Your Honor, when we were given a copy of the DVD that has mention of marijuana and other terms for it, yes, we will agree that the video can come in, but there's portions of it that cannot come in due to a prior ruling on a motion in limine.
And to those portions, Your Honor, the state has no objection. We would obviously follow the orders of the court. I think that the issue then becomes if there are additional redactions that the state feels are relevant, regardless of your decision on 911 call and on certain video footage after arrest. This occurred 3 hours before an arrest was made. Is certainly more probative to the defendant's mindset at the time that he was seen driving, close to driving, and therefore a determination can be made by the court as it relates to the admissibility and the weighing of that defense.
Any response to that?
Well, the officer is under subpoena and knows to be here for trial tomorrow. So any observations he had, anything he saw as far as going towards impairment can come out in when he testifies at trial.
And I'll note that Mr. Smith is not present, which I don't think I ever noted for the record. Have you had a conversation with Mr. Smith about this new video?
I have. I was present for the conversation for purposes of the record. He and I spoke as well.
Well,
Ultimately, Your Honor, at this hour, I think it's probably most appropriate.
I agree. All right. So the court's going to order a continuance for the discovery violation. We're going to continue this case to March 8th at 9 o'clock for a calendar call to be and trial March 9th. Pursuant to the COVID-19 procedural rules, make sure all motions are not only filed but heard prior to trial.
Judge, if I may,
Yes.
the plea offer, which was revoked last week, stated to be state until the next pre-trial and trial call.
All right. We're just going to continue it to the calendar call. We're not going to continue it to the pretrial. Should the defense change their mind and decide to accept a plea offer, or if a new one is negotiated, you can always add it to an earlier calendar date if you choose to.
Your Honor, I'm not, forgive my ignorance, since the continuances and the defense, the last one was due to the discovery violation, was the state charge continuance or charge of
Charge to the state. Will you call the clerk and let them know no jury trial tomorrow? Or Friday? Yep, thank you. Okay. Anything else we can discuss about this case?
I don't think so.
I don't think right now.
All right, anything else to come before the court?
I need the evidence, please. Don't leave without giving it to me.
Right, don't forget to give the evidence regarding the motion in limine.
Madam Clerk, I'll bring it down to your office,
When?
right after we get out of chambers, or after we get out of court.
Can you get it?
well, wait, so it's
There should be really action within.
As we know, it's our available judge, so.
Okay. Do I need to set it for a pretrial in order for you to determine your witness availability?
Judge, to be safe, I don't make any representation support. I would like that to be set for pretrial just to ensure that our witnesses are in fact available.
All right, any objection to that?
I'm sorry, what was that?
The state's requesting that we also set it on a pretrial conference docket of February 25th, just to verify witness availability for the trial week.
I prefer to set it for trial calls when we have a date certain for clients to make arrangements to get to it.
So is that an objection? Denied. We'll also set it for pretrial conference on February 25th, but go ahead and keep the calendar call and the trial date. All right,
So
thank
now
you.
you're putting it on a pretrial date, is not taking it off the calendar call.
Correct.
Thank you.
All right, anything else then?
No, Judge.
All right, that'll conclude